life in prison without the possibility of parole. The cases that have been filed need to be heard. There will be constitutional claims that will be raised related to whether these people have vested rights under the old laws. We don't need to waste the taxpayers' time, resources, and money litigating them. Let the claims be heard, let the law stand, and let our judges do their job.
My name is Ken Rose. I'm a staff attorney at the Center for Death Penalty Litigation. I want to talk for a minute, go back to the original passage of the Racial Justice Act, why it was passed, and where we've come and what we've learned since in the litigation, and make the connection between innocence and the Racial Justice Act. Those of you who covered the act, the passage of the act several years ago, remember that there were 3 exonerations in the previous 5 years before the passage of the Racial Justice Act. All 3 persons were persons of color. And there was a great concern in the legislature at that time that there was a connection between race discrimination and those wrongful death penalties. And what we have learned since is it strengthens those concerns. What we've learned since is that of the persons who are on death row, over 30 of them had no persons of color in their jury. And over 40 additional cases had just 1 person of color in their jury. So what is the connection between innocence and a diverse jury? We've heard social science testimony in this litigation that's came since the passage of the Racial Justice Act, that there's a direct connection between diversity in juries and better determinations and more reliable determinations of guilt. So we know there's, from social science studies, from experts, that diverse juries yield more reliable, more accurate results, less likely to lead to wrongful convictions. What we also know is that many of the cases of persons currently on death row did not have diverse juries. By the legislature repealing this law, we're turning a blind eye to the risk of executing more innocent people.
Mr. Tahan.
Yeah, my name is that me? My name is Ty Hunter, and I'm a lawyer at the Center for Death Penalty Litigation, and I was actually one of the lawyers who has actually litigated these Racial Justice Act cases. And the thing I want to comment about is the imaginary version of the Racial Justice Act that the proponents of this bill are talking about here today. I went to the Senate hearing where the prime sponsor of this bill talked about the Racial Justice Act, and his talking points were this is that the Racial Justice Act is all about numbers. It has nothing to do with the actual conduct of any prosecutors, and it's just we're manipulating numbers, and that's what the Racial Justice Act is all about, and it's ridiculous and we ought to get rid of it. Well, if you believe that story, then it is ridiculous and we ought to get rid of it. But I was at the hearings that where Judge Weeks presided, and if anyone, if Senator Goolsbee would bother to go and read Judge Weeks' more than 200-page order, he would find that Judge Weeks found that his decision was based primarily on the conduct of the prosecutors in those cases. Their racially prejudiced conduct in those cases was the primary basis for Judge Weeks' decision. Not numbers, not what happened in some other part of the state, not what happened in some other case, but what actually happened in those cases. He found race discrimination by those prosecutors in jury selection in those cases. And that was the primary basis for Judge Weeks' order. You never hear that from any of the people in their pretend version of the Racial Justice Act. And that is what we are trying to repeal. We had an act that says, okay, you're allowed, if you can show something, you're entitled to relief. And so we've had 2 hearings where we showed something and we got relief, and now the legislature is saying, no, we don't want to know about that. So this is not about numbers. This is about actual race discrimination by prosecutors in these cases that was found by Judge Weeks, and now the legislature is trying to turn a blind eye to it. So thank you very much.
Ms. Phillips, representing the NAACP.
Thank you. Good morning. I'm Jamie Phillips. I'm here on behalf of the North Carolina NAACP and our president, Reverend Dr. William Womble. Last week during Holy Week, the church remembered the death of an innocent man, Jesus Christ. He was killed by a Roman system of capital punishment applied in a discriminatory way against the Jewish people. The Republican leadership in North Carolina General Assembly want to restart state-sponsored death that has been proven to be riddled with racial and class bias. The North Carolina NAACP is unequivocally opposed to the death penalty. However, even if you are a proponent of the death penalty, you should be against racial bias playing any role in its application. The Racial Justice Act was passed with the support of proponents and opponents of the death penalty. All agree that racial bias has no place in the application of the ultimate punishment of death. Last year, the North Carolina General Assembly gutted the RJA's most important parts. They claimed systematic racism clearly shown in statewide statistics somehow shouldn't be considered as evidence of racial bias. Still, some want to go back in time because pieces of the law are still working, but more importantly, they have ideological opposition to racial justice. And now, Senator Goolsbee and others want to simultaneously roll back protections against racial bias executions by repealing what's left of the Racial Justice Act, while at the same time restarting the death penalty. All the evidence shows that the death penalty system is flawed with racial bias. So why would you rush to send more people to death? What is the rush? We should be strengthening the Racial Justice Act, not doing away with it. Do not repeal the RJA. A death penalty system that is flawed with racial and class bias is tragic and must be continued to be corrected and must not be ignored. Thank you.
Hi, my name is Marcel, and I'm representing Murder Victims Families for Reconciliation of North Carolina. Murder Victims Families of Reconciliation is an organization whose members have experienced the trauma of having a loved one murdered. Our members have so much in common with the victims' families who have spoken in support of 306, and we look forward to a day when we are not divided by the death penalty, when we can stand here together and advocate for what serves victims' families best. North Carolina can do better for families of homicide victims and all citizens than restarting executions. We can do better to restore confidence in our judicial system than removing a reform that is working. We need a serious conversation that leads to smart on crime solutions that better prevent violence and address the harms created by violence, help families heal, and build safer communities. Legislation to repeal the North Carolina Racial Justice Act and to restart executions is a distraction from the serious conversation and action that is needed. The North Carolina Racial Justice Act has helped to expose, correct, and prevent race discrimination in death sentencing. While at times painful and inconvenient, the treatment is working and needs to be allowed to continue. Confidence in our criminal justice system is not aided by removing a reform that is working and correcting flaws in the system. Numerous murder victim family members worked in support of the NC Racial Justice Act over the past several years because they believe it helps North Carolina provide a higher quality of justice, a justice not tainted by intentional or unintentional bias. All lives matter, regardless of race. We deserve a judicial system that values all lives and treats all persons fairly, regardless of any individual's race. Too much time, talent, and treasure is diverted to the very few cases that ever result in a death sentence. Meanwhile, thousands of murder victim family members in our state go without the most pressing and basic needs being considered. North Carolina would do better to direct more resources to help law enforcement solve unsolved murders and bring offenders to justice. We better serve victims' families by making counseling more accessible, providing advocates who work for victims to help them be informed about investigations and judicial proceedings, and expanding financial compensation to help them with burial costs and work time lost due to the murder. Executions should not be resumed unless its proponents can demonstrate that it is the best way to make us safe. It is the best way to address the needs of the thousands of murder victim family members across our state, and can be done without racial bias or risk of executing an innocent person. Thank you.
Stayn Griffin, Legislative Black Caucus. We're glad to have all these folks sharing with us today. And we do want to remember in his absence Representative Larry Womble, who fought a gallant fight for this legislation. We want to thank him in his absence. We want to thank Judge Weeks in Cumberland County for the courage that he had to stand firm. I know that he was facing much opposition, but as we all know, the death penalty is something that you cannot reverse once you have, I use the word, killed an innocent person. So we need to do all that we can to ensure that we're doing the right thing in the General Assembly. And to those who are proposing legislation that will reverse this, we need to have a serious conversation with them. And I know that we will in this process, but it's final. Once you, as we said, you an innocent person. And I think there are people probably standing behind me today. I know one in particular that found himself in that situation, and it was proven that he was an innocent person. Had not the opportunity, had not there been an opportunity for him to do that, he would not be standing here today. So we need to be very careful repealing this legislation, because it's going to send a signal, as some have already said, to our communities. So we're going to do all that we can. We'll fight. The Legislative Black Caucus will stand and fight. We realize that we're outgunned and we're outmanned, but we will stand firm in fighting for what's right for our citizens. Thank you.
Senator Bryant.
Senator Angela Bryant, District 4, Nash, Vance, Warren, Halifax, and Wilson counties. I just wanted to make a couple of comments. As a constitutional officer myself, I'm concerned about the fact that our district attorneys as constitutional officers are pushing for a repeal of this act, when we know that the integrity of our system and the fidelity to the constitutional principles involved in our criminal justice system is what makes it harder to convict innocent people, to make mistakes in the process. And the idea that they would object to having their own behavior reviewed, given that there has been significant documentation that practices they have engaged in, which perhaps with good intentions to their desire to win their cases, does not meet constitutional muster. If I were them, I would like to see them being interested in uncovering any of such behavior that might be involved in our criminal justice system and helping to restore the integrity we need going forward. If there's discrimination against me as a juror, if there's an assistant district attorney of any race or DA of any race who has in their mind some sense of prejudice against me that would not allow me to serve on a jury in a way that they would not apply that same standard to whites, that discrimination not only harms me, but it harms the white person who's the defendant. It brings all of us into a web of racial discrimination in this very sensitive constitutional process. So it not only hurts that one person, but it hurts everyone participating. We're all drawn into it, and now they're drawing us as a legislature and as a state into complicity in this unconstitutional and unfair process. And I just think that needs to be emphasized and called out. And the other thing is that while the people involved in the actual cases, the people who've been convicted, and in most instances, many of them may be guilty of their crimes, that is not the fact that they are not the desirable people or the people that would be most where we would be most anxious to support is not so much as important as it is our fidelity to this constitutional process and to these principles that bring integrity into a system that we all participate in and support in and can be victims in. And we see on a weekly and daily basis that there are mistakes made in this system. It's the same kind of thinking that has us having evidence that's not properly vetted, that has mistakes in our labs, that has mistakes in bringing forth information. A whole sequence of errors that we've seen in recent years, the DNA errors, the refusal to grant motions to bring evidence forward. All of those types of behaviors are symptomatic of this same issue we're facing here in the Racial Justice Act, and it's important that we stand up and draw the line somewhere. To have integrity in the system, we have to stand up against this pernicious discrimination for this most permanent penalty, in this case, which is death. So thank you very much.
Would you like to speak, Representative Paul Luke?
Thank you. Representative Paul Lupke, 30th House District, Durham. I just want to speak briefly and just make a couple of points. That first of all, with Representative Larry Womble, who's been referenced, we fought very hard for a death penalty moratorium a number of years ago in the House. We came extremely close, and we made that argument. The argument for was precisely the issues that are raised in the Racial Justice Act, that evidence of systemic discrimination in the death penalty process. We came within a vote or two of having that 2-year moratorium, where we really then wanted an exhaustive study to look at that. We failed, but then we're pleased that then just a few years later we were able to pass the Racial Justice Act. And I just want to say that it is a biracial effort on the part of General Assembly members, House members, when we passed the RJA. I was a primary sponsor. Other members here were strong supporters, as I say, whites as well as blacks. It should never be perceived that white members of this General Assembly are not in solidarity with, in strong coalition with, our African American colleagues. Just want to really stress that point. I'm offended by Senator Goolsby's bill and feel like it undermines the excellent work that many have done. Attorney Rose just so heavily involved in this, and we appreciated his efforts, and I appreciate everyone who's spoken before me and spoken so well. So I'll just stop right there. Thank you.
Thank you. Again, we at this time will take questions, but before we do, just wanted to follow up. I've heard one of the senators say, well, under this act, white people have filed. The fact that racism exists and a white person can file under the Racial Justice Act show that's why it's needed. Black jurors were excluded, and he was not able to get a trial before his peers. So while people think it's just about African American, it's about fair criminal justice system that serves everyone fairly. This time we will take questions.
Is your issue primarily with the Racial Justice Act portion of the bill, or do you also have concerns about the portion that wants to potentially restart the death penalty?
Senate Bill 306 is a terrible bill. The whole bill is unneeded in the state of North Carolina as we move forward. However, we understand that the Republicans in charge, and they make sure we know it every day. And if we're going to start death penalty back, we need to ensure that we do have equity and fairness in our criminal justice system. The Racial Justice Act will ensure that, even with the death penalty back in force in the state. Other questions? Not? Thank you. Thank everyone for coming.
Absolutely. Hang in there.
Yes.
Well,